Welcome to EUPrivacyForAll, transparent information and modalities for exercising the rights of the data subject, Article 12, Session 31 on GDPR. Practically, to exercise their rights, data subjects could have benefited from European Parliament suggestion. So indeed, they can exercise it electronically. The proposal for 40 calendar days to be considered as without undue delay was not retained in the end, and the remote access to a secure system was not laid down as such. The fourth proposal of the European Parliament on charging a reasonable fee, taking into account the administrative costs for providing information where requests are manifestly excessive, was retained. EU Council, on its side, specified that the information shall be provided in writing or by other means where appropriately in electronic form. It could be given orally also if requested by data subject. Controllers would have the obligation to facilitate the exercise of data subjects' rights, and there is an extension of the period to provide information by 2 additional months. The controller also, if not sure about the identity of the requester, may have the possibility to request provision of additional information. In the final draft of Article 12, most of the proposals by EU Parliament and EU Council were retained. So basically, a controller shall be using clear and plain language, in particular for any information addressed specifically to a child. This information shall be provided in writing or, where appropriately, in electronic form. It could also be orally given whenever the identity of the data subject is proven. The controller shall also facilitate the exercise of data subjects' rights and not refuse to act unless it demonstrates that it is not in a position to identify the data subject. The controller shall inform data subject about the action taken without undue delay, that is to say 1 month, or at the latest within 3 months, when it is necessary. If any delay may occur, the justification shall be provided within 1 month to the data subject, and the possibility of lodging a complaint or seeking a judicial remedy. Whenever requests become manifestly unfounded or excessive, the principle that they are free of charge can be modified, and a reasonable charge and fee could be implemented if the repetitive character of the requests justify it. In such a case, the controller has the burden to demonstrate it. If the controller has reasonable doubts on the identity of the individual making the requests, he may request provision of additional information. The information to be provided to data subjects may also be provided in combination with standardized icons. The Commission will be in charge, through the drafting of delegated acts, to determine which information could be accompanied by icons and how it would be implemented. Several recitals contribute to the understanding of Article 12. Basically, Recital 30 makes clear that the easily accessible, easy to understand, and clear information is a basic obligation for data controllers. Recital 48 reminds that a fair and transparent processing necessitates to provide any further information necessary to the data subject, potentially providing standardized icons. Recital 129 makes clear that the use of those standardized icons will be framed by delegated acts. Currently, the directive does not lay down any provision on transparency of information specifically, nor on standardized icons or clear and intelligible language. But Article 10 and 11 already frame data subjects information. What should accountable data controllers get prepared for? First, provide an easily accessible and easy to understand information, using clear and plain language, in particular if it is addressed to a child, in writing, or if appropriate in electronic form, and when requested by the data subject orally. In such a case, the identity of the data subject shall be proven. Facilitating the overall exercise of data subjects' rights is key, and the controller cannot refuse to act unless it demonstrates it's not in a position to identify the data subject. The information shall be handed over without undue delay, that is to say within 1 month, extendable for a maximum of 2 further months. In 1 month also, if not taking action, the controller shall inform the data subject and also on the possibility to lodge a complaint before a DPA or a court. The controller can charge a reasonable fee if it demonstrates the requests are manifestly unfounded or excessive, potentially repetitive ones. In case of reasonable doubts on the identity of the individual, the controller may request additional information. And finally, the information may be provided in combination with standardized icons. So what will be interesting now is knowing more about those icons that will be framed by EU Commission delegated acts.